Good afternoon, everyone. We are here with Ruby Powers, and we are going to talk about immigration best practices, affirmative asylum. So we are here with Powers Law Group. Ruby is a board-certified immigration attorney and nationality, and we are also excited to tell that she's been working in this for almost like 13 years. So thank you so much, Ruby, for being here.
Yeah, thank you, Liana. Yeah, the firm is 13 years old and I've been practicing 14 years, but I've been in immigration a lot longer beforehand. So, this is a really important topic. We're going to talk about affirmative asylum. We've seen a lot more asylum seekers since a lot of the travel restrictions have been released, sort of lifted after the pandemic. And so we want to just do a refresher on this. We have a lot of experience in asylum. We have many cases from all over that we've helped individuals apply for. So we're going to go over this and we're going to cover this again in Spanish on Friday. So feel free to share this with someone that you think needs to watch it. So we're moving on. So just a little bit about us at Powers Law Group. Even before I was an attorney, I did it one of my first immigration asylum court cases was in the immigration clinic, and it was an asylum case when I was a law student. But here at the firm, we've helped individuals apply for asylum to the United States from at least 34 different countries. And we do help individuals affirmatively and defensively, which means also in immigration court as well. So we're well versed on lots of different scenarios, not one particular situation. So ultimately, the super basics, if we were just to distill it down to the what you really got the crux of it is, and this can be really complicated. You could take a whole law course on asylum, but we're trying to get it down in just about 10-15 minutes, is that a person has suffered past persecution or have a reasonable fear of future persecution. So past and or fear of future on account of one of five protected grounds. And a lot of this is coming from human rights law, Geneva Convention, a lot of past laws that this is what many other countries also do, something around the similar grounds. And ours can be tweaked through case law, but basically five things: race, religion, nationality, membership in a particular social group, which what that means is it could be like journalists who write against the ruling party, or it's something that's identifiable, characteristic. They say immutable, which means you can't change it. And this is sort of where you can craft your situation in this particular social group. And then the other one is political opinion, which is funny because a lot of people call this asilo politico or think that it has to be a political situation, but it doesn't have to be. That's just one of five grounds. Now, other things to consider is that there's nowhere else in your country that you can relocate. If you could go to the east and you'll be fine, then you don't have grounds for asylum. You can go to the west or the center, or you could just relocate and you're not going to have the same problem, then you won't be able to win asylum. Now, you also need to prove that you have no other citizenships or visas to go to. But if you did for some reason, like let's say you had a tourist visa somewhere, it doesn't necessarily mean you can live there. So maybe your visa had expired. But if you have legal permanent residency or citizenship in another country, you'd have to argue that you're afraid to go to those countries as well, and why you couldn't relocate. Now, this is where a lot of people have an issue. You have to apply within 1 year of entry. Now, there's some exceptions. There's changed circumstances and there's extraordinary circumstances. Exceptions like this could include you're still in status on an F1, or you're on an E2, or maybe like the change in circumstances in your home country, or maybe your attorney passed away, or you got really sick, or there was a change in your marital status that disrupted your ability to file timely. So there could be reasons, but they generally say you need to apply within 6 months of that change to show that it's still timely. And you must be physically present in the United States. So when sometimes people get this confused and they think refugee asylum, they get them all mixed up. But refugee is when the person that comes from abroad and has been classified as a refugee, waited their turn to be resettled, and comes to the US already with a status. Asylum is when a person enters and is here and applies for asylum and waits to see if they're granted. So if we went more detail about the 1 year filing deadline, the changed circumstances, changes in the law, country conditions, relationship, uh, and and if you can verify that and ideally file within about 6 months of that change, you can often overcome the 1 year filing deadline. It also depends on where you're applying. Some circuits are more sensitive about the 1 year filing exceptions than others. Examples of extraordinary circumstances: disability, extreme illness, death of legal representation, maintain lawful status. So those are some other exceptions.
Ruby, can I ask you something? So
Go
when a
ahead.
person gets asylum, they can they work at the country they're like for example, one person gets asylum from the United States, can they work there?
Oh, well, that's everybody wants to know the answer to that question. So after you've applied for asylum in the United States and your case has been pending more than 150 days, there's some other exceptions about, I'll just say this in general. Then you can submit your work authorization, and after 180 days have elapsed, they should approve your work authorization. Your work authorization would be good, valid for 2 years. And as long as you renew it and are still case pending before it expires, then you will get an extension while your work authorization application is pending. In fact, they recently stated that while your work authorization is pending, for a renewal that was timely filed, you would get a 540-day extension. But if you cause any delay, like if you're in immigration court and you cause a delay on your work authorization, they can stop the clock. If you ask for continuance, if you change venue, that's you doing that, then you can stop this imaginary but very important asylum clock, and you won't be able to restart it until you move the case along. So you really have to watch out for any delays that you can cause. But for the most part, there's also this other thing called the ASAP membership, and if you're a member of that, usually you can get a faster result on your first work authorization. But if you look at some of the processing times on the work authorization, they can be quite lengthy. They are, I think they're trying to get that backlog done. But the short answer is yes, there is work authorization in certain circumstances, but only after you've applied for
Oh,
asylum. So, what are the steps to this whole process? Well, first, if you're you have to be in the U.S., then you would analyze eligibility. That's where I would highly suggest a highly qualified asylum immigration attorney to review your case, let you know what your chances of approvability are. Then you can apply. Then you would get a receipt. Unfortunately, at the time of this recording, which is late August, we got our receipt in 4 months. That's the longest in my entire life I've ever taken to get a receipt for an I-589. Afghan clients in 1 week. That we got those yesterday. So once you get the receipt, you'll also get a fingerprinting request unless you've already been put in the system, and then they'll reuse your biometrics. And then you wait. At some point, you'll get an interview notice. At some point, then you'll have the interview. Then the officer will make a decision, and then you'll receive the decision. So we'll walk through these different steps. So just to let you know, if you want to find out more information, you can go to the USCIS.gov website and you can look up asylum, and it has some information there that can let you know, you can keep an eye out for and learn more about it. So the application is the I-589, which it looks a little bit like this. It's 10 or 11 pages. I should know, they don't change it that much. And I do have some suggestions on how to improve that. Um, so then there's a personal statement, which is really important. So a lot of clients, they fled their countries with just the clothes on their back and they don't have a lot of evidence. But really what is important that their story, and that there needs to be detailed, it needs to be compelling. It needs to explain how they meet the elements. And writing this statement is really important. And this is what can take some time. So you want to either have it show the original language in the translation, or you want to make sure that you can show that it was translated, transcribed into English from whatever language that your native language. Then you want to also make sure you have your birth certificate, if you were married, marriage, proof of. You just want to basically your biographical documents, and you also want to be able to show country conditions and so much more. So and maybe even a map of the country to explain why you can't relocate. Like there's a ton of proof that you want to show, and but this is just the beginning. So we're just giving some basics. Now this is the I-589. There's lots of questions. It's a lot of biographical in the first 4 pages, and then there's a lot of stories about questions about your story and have you been harmed? Why have you been harmed? How quickly did you apply? And so this is about 10 to 11 pages. You can add addendums if there's a lot more answers that you need to make. But usually if you write a statement in your application, then we, on the questions after page 4, we usually say see statement or see attached statement so that the individual can put it more in a story narrative form. But this is important. And then moving on to once
Ruby,
it's received.
I have a question from a watcher. So Melissa said, just to make sure I understood correctly, the
Okay.
applicant has to wait 150 days after filing for affirmative asylum to apply for EAD.
So yes, that's right. But there's some different provisions as to you need to double check if you're in immigration court. You need to call the 1-800 number and double check how many days have elapsed. Because if they say that you caused any delay, then they're going to deny your work authorization. So that's why I don't want to say a blanket statement 100% across the board, because but in general, 150 days after you have receipted and submitted your I-589, then you show a copy of that receipt, and as long as the clock did not stop, then you can submit the work authorization, and then you would they cannot approve your work authorization until 180 days have surpassed total. So in theory, it's like giving them 30 days to make the application and turn it in, but it doesn't happen that fast. And let me just say that the 1-800 number for immigration court, if you happen to be in court or you were given a notice to appear, but you weren't, it wasn't properly filed, this is where it gets really confusing for people. But could have filed it affirmatively if you're not technically in court. The 1-800 number for immigration court to call and put your A number in, if you have one, is 1-800-898-7180. But yes, if you have, I would say if anyone filed for asylum on their own and they have questions about work authorization, to just have a consultation and double check everything before they submit it, because they don't want to have to wait a long time and then it get rejected for some reason. So if you haven't.
She also asked, when filing for affirmative asylum, do we submit one original plus one copy of the entire filing for main applicant and one copy for dependent spouse?
Wait, are we talking about are we talking about the work authorization or the I-589?
For the asylum, yeah.
Yeah, so you have to read the instructions, but it generally wants you to submit one for the primary and a copy for the dependent. And sometimes it can be confusing when you read the instructions as to how many copies that you need. But the general idea is that they're going to make an A file, an immigration file for your dependent. And so they want a copy of the I-589 for them in their file. And so you're sending them. Now, this is for the paper filing. There is a way to file electronically online. And we really didn't cover that in this presentation, but there is a way, and that is a way to get potentially your receipt and your interview a lot faster via the USCIS.gov website. But yeah, lots of really practical, good questions. So I guess for fingerprinting, that's pretty obvious. They'll either reuse it if you've already had it in the system somehow, but most people haven't been input in the system, and so they're going to have to go do them. Then you wait for the interview notice. So in January 2018, they made a change and they said everybody, we're going to do LIFO, last in, first out. And what that means is that the last person to file will get the first interview. And they were trying to make people who filed more recently get the interview sooner. Now, that didn't always work necessarily. They also had these priorities. They were trying to give priorities to people who had rescheduled the interview. The second was to applications that have been pending 21 days or less. And then there was also the new third will be for newer filings. They also were doing them for unaccompanied minors and things like that. Now, what have we seen since then is that sometimes it still takes years to get an interview. Sometimes we'll get one in 6 months. I really predict that with a lot of the Afghans filing for asylum right now, because they've been here a year, I predict that the asylum offices are probably going to get slowed down with the onslaught of the Afghan asylums, and so it might get slower, more slow down. But you also could look to see the asylum offices that have jurisdiction over where a lot of the Afghans were resettled might be the ones that are going to be slowed down the most. But there are 8 asylum offices and 2 asylum sub offices. And this interview notice is going to give you the date, the location, time, and it's going to give you a lot of other information like about what to bring. And so that's why we have this slide. So, sometimes what people do is they might file on their own, or maybe a nonprofit helps them, but then when they get the interview, they hired a private attorney or attorney to help them, and maybe they'll have them be prepped. Highly suggest getting a preparation appointment, be prepared for the interview, and then they might hire an attorney to go with them to the interview. We do that a lot for individuals who filed maybe on their own or changed attorneys. So on the day of the interview, you're going to want to be there a little bit before the time it tells you to be there. You're going to want to bring a translator if it says that you need to. It sort of depends on the language and their availability. You're going to want to bring your ID, your birth certificate, civil documents, a copy of your I-589. And if there's anything you want to give more to the officer, it's usually better to email them in advance to the asylum office and then bring a copy just in case the asylum officer doesn't have it in their file so they can review it. You're also going to want to bring any the derivatives with you at the time, like spouse and children under 21 that were included. Maybe they're over 21 now, but they're still eligible to be your derivatives. And usually those individuals will just do a security clearance, and then they could sit in the lobby. They don't have to stay in the interview the whole time. Everything that's not in English needs to be translated into English. So for the officer.
I'm sorry. Melissa also asked, affirmative asylum, I understand, is through USCIS. Does the 180 day rule apply before applying for EAD for those that aren't in court proceedings?
Yes, it does. It does. It's the same rule. It's just that you need to call that 1-800 number and put the A number and double check. There's a provision. I think it might be number 2 when you put it in. First you listen to the prompt, and then you listen to, I think it's 1, and then you put the A number in, and then you listen to it, and there's a number. It's been a little while, but that tells you how many days have passed since on the asylum clock. And as long as you're over 150 days when you file it, then you should be fine as long as you don't cause any delays. But sometimes when there's a change of venue or you ask for continuance or you're not prepared, then the judge might code it as a delay and then on your part, and then they might stop the clock. So that's why I don't want to say it's just flat out 150 days, because you have to make sure that the clock is still working and hasn't been stopped. But yes, I mean, in general, the asylum clock is the same for court as it is for affirmative. It's just that most likely the court can be stopped a lot more frequently because of delays or codes in the system. But if you have a lot of specific questions like that, I'd highly suggest a consultation because then we could get you the right answer specifically to your case. But that's the general answer. So back to the interview preparation. When we know we're having an interview, we make sure to look at the statement and all the documents. We make sure that there's any edits that need to be made to the I-589. Some cases are 4 or 5 years old. Some cases are just 5 months old, but there might be something that needs to be changed. I ideally suggest to bring a list of amendments or maybe make a copy with highlighted edits so that you could show the officer really quickly as you walk through those. You don't spend too much time on that. You want to double check you have a translation for everything, and you want to see what else you need to update. And we also simulate a mock interview. That's really so valuable so our clients know what to expect on the day of. Because in the day of the interview, we're making notes, we're observing, but it's really all about the applicant making sure that they answer and share their story. So the major points of asylum interview are reviewing the application, and that's why having those edits and any changes in knowledge of that application are super important. The second is going over the story in the statement. They've already read the story in the statement, but the applicant, is supposed to answer specific questions that the officer wants to hear directly from you. And the third is the security questions. And these are the typical ones to make sure that you don't have any inadmissibilities and that you're eligible for asylum. So some of the things that can cause red flags to the officer would be like delayed filing, uh, maybe the statement's a little confusing, or the timeline is not in order, or the words. That's why it's really hard for a lot of applicants that don't have someone knowledgeable about the process to put their story on paper, because maybe it's a second language, or they're very traumatized, and a lot of times they don't think about the whole story in chronological order due to the trauma. If you've gone to if you've traveled to other countries, or you went back to that same country you have fear from, that can cause issues as well. And if you've traveled to certain countries that have known terrorism, they want to learn more about that. And they might put you on a very long background check that could cause a lot of delay. And if you have something bad happen, but you don't have a connection, what we call a clear nexus, to one of the 5 protected grounds, then they'll just think it's maybe general violence that has no connection to why you should be protected. So that's why it's really important to have a experienced immigration attorney review all of this. Um, if the client doesn't answer, if you don't answer the question, or you don't, you can't think of it in a timeline of chronological order, or if it's the translation is bad, or maybe the translator that you have, or that the asylum office has, is not doing a good job. A lot of these things can have an impact on the interview. I've been in so many hours of interviews. I know a lot about these things. And so even like body language, the officer is observing the client, the applicant. So there's a lot to that. Now, generally what happens is that either the decision is mailed to you, or you come and pick it up. Now, it depends on the office, but generally, if you're not in status, they will make you come pick it up in 2 weeks. But also, if you live more than, I think, 100 or 120 miles away from the office, then they'll mail it to you. So you just really ask them what they're going to do, and they'll tell you at the interview what's going to happen. Is it going to be mailed to you? Is it going to have to come pick it up? And you go from there. Then I just wanted to say that we have a lot of experience in a lot of these different locations, from Houston, New Orleans, Arlington, Boston, Newark. I've gone to all of these asylum offices, and we've even had clients in Miami and other locations. So now there's a way for your attorney to observe the meeting via phone or video, so that they don't have to physically go. But since immigration is federal law, we are able to represent you anywhere in the United States. So we do have clients from all over the U.S. that we're able to help. So that's the end of our August webinars. So far, we've done TPS for Venezuelans, TN visas, overview of immigration agencies, what happens if I overstay my visa, and today we did affirmative asylum. Now, just if anything was of interest to you, you want to ask more questions, feel free to give us a call for a consultation, and we can go into more depth. We usually ask that you write a statement, a little bit about what you're applying, and so that way we can go into hit the ground running in the consult and really just go to the crux of the case. And we do help people who filed on their own and need us to represent them at the interview. And we do help in immigration court around the country. So, Ileana, what do we have coming up here in September?
So for September, we have overcoming complex naturalization issues and when to hire an attorney. We have the roadmap to a successful national interest waiver petition, bond hearings, and we also have legal permanent resident reentry, how to preserve residency.
Yeah, these are all really important. And I know in October we're going to do one on DACA because that's in the news now too about being going into effect in later in the end of October. So how can they find out about us in the future?
So here we have all the social medias. You also have our number. So if you want to reach out to get any consults with Ruby or the other attorney that is in the Powers Law Group, you can. Don't forget, if you have any more doubts, you can always reach out through these medias, and you can also see all the new news updates in all of our social media platforms. Thank you so
Thanks.
much, Ruby.
Thank you, Ileana. Thanks everyone who watched. And if you have another topic you want to hear from us, just let us know. We'll get it prepared and share that information with you.